Good afternoon. My name is Thomas Bona. I'm a partner at Pillinger Miller Tarallo, and I'd like to welcome you to our fifth Pillinger Miller Tarallo Greenberg School of Risk Management Conference Webinar Series, and I'm today's moderator. When we began our conference webinar series almost 4 years ago, our goal was to provide cutting-edge ideas, concepts, and strategies from industry experts and thought leaders that affect our industry. And I'm very pleased today to introduce the Pillinger Miller Tarallo Claims Settlement Institute. For those of us who are not familiar with Pillinger Miller Tarallo, we are a regional insurance defense firm. We have offices in New York, New Jersey, Pennsylvania, and Connecticut, and our focus is very simple: results and value with swift, cost-effective resolution of cases. We're known for being able to resolve cases, and our focus on resolving cases starts from the moment we get a new file in the office. This year is also Pillinger Miller Tarallo's 20th anniversary. So we thought that we would take our experience and our knowledge settling cases and combine with like-minded stakeholders from plaintiffs, defendants, insurance, claims, judges, mediators, and create a vehicle to advance the art and science of settling cases. So welcome to the PMT Claims Settlement Institute. I'd like to thank Dean Norianne Sharp of the Tobin College of Business for her support of our conference webinar series. As I mentioned before, both the firm and myself have deep ties with St. John's, and so we're very happy to be working together. I'd like to thank Dean Brandon Schweitzer of the Greenberg School of Risk Management. I'd like to thank Larry Pistel from the Center for Executive Education, and Joe Levine from CC&G, which is PMT's branding and marketing partner, for all their help putting this together. So let's kick off the Pillinger Miller Tarallo Claims Settlement Institute. We have 2 sessions today, and I think you'll find them informative, interesting, and provocative. Our first session, we're going to talk about some resolution strategies that I think you'll be able to take and use immediately. And we have a panel of industry leaders who are going to help us with that. Our second panel, we're going to be looking at the results of the PMT St. John's Claims Settlement Survey. We'll be talking about settlements in 2020, settlements in 2021, and we'll be seeing what conclusions we can draw and what we can learn from our survey. I'd like to thank our participants for being part of our webinar today, because without participants, we can't do a webinar. But I'd also like to thank our panelists, because our panelists, they give us their time, their expertise, and we're very, very grateful for that. So thank you, both our participants and our panelists. One thing I do want to mention is that from time to time, there are going to be some polling questions. And the polling questions are necessary so that people can get CE credits. So when you get the polling question, you have to answer it to get the CE credit. So I'd like to first start by asking our panelists to introduce themselves and tell us a little bit about them. Jeff Miller, would you please tell us a little bit about yourself?
Sure. Jeff Miller. I'm one of the founding members of Pillinger Miller Tarallo. And as Tom mentioned, celebrating our 20-year anniversary. I work out of our Elmsford and New York City offices for the most part, and I'm looking forward to a great seminar.
Thank you. Jeff Schulman, would you please tell us a little bit about yourself?
Yes, good afternoon. My name is Jeff Schulman, as Tom indicated. I'm a partner at Pillinger Miller Tarallo. I run the upstate offices, which include Syracuse and Buffalo, and happy to be here today with you all.
Thank you. John Tambasia, can you please tell us a little bit about yourself?
Thank you, Tom. I'm a partner at Pillinger Miller. I've got 30 years experience, so I haven't been doing this very long. I practice out of both the New York and New Jersey and occasionally the Philadelphia offices and state and federal court.
Thank you, John. Professor Al Beer, could you please introduce yourself and tell us a little bit about yourself?
I'm Al Beer, professor of actuarial science and risk management at the Greenberg School at St. John's University. Had a 40-year career in insurance before I joined the faculty, and currently I serve on 4 insurance boards. Happy to be here.
Thank you, Professor. Professor Jack Jennings, could you introduce yourself?
Hi, I'm Jack Jennings. I'm an adjunct professor at St. John's School of Risk, and I have 45 years of experience in insurance and risk management.
Thank you, Jack. Joe Donahue, could you please tell us a little bit about yourself?
Good afternoon, everyone. How are you? My name is Joseph Donahue, and I'm a partner at the law firm of Block, O'Toole, and Murphy, and we represent plaintiffs in personal injuries, catastrophic injury cases. Looking forward to what I think is going to be a great discussion today, and thank you for having me.
Thank you so much for joining us, Joe. And Judge de Blasi, could you please introduce yourself?
Thanks, Tom. My name is John de Blasi. I'm a retired justice of the Supreme Court, and I've spent the last 16 years with National Arbitration and Mediation as an arbitrator on a full-time basis.
Thank you, John.
And Tom, before we start, we've had a
Yes.
number of questions already just about CE and CLE credits. I have typed answers that we will be providing that information, and that John Tambasia will help guide us through that process. But I just wanted to let everyone know out there that we'll be taking care of that for you at the end. Is that correct, John?
That is correct.
Thank you, Jeff. Thank you. And finally, Nancy Kalinoglu, could you please tell us a little bit about yourself?
Yes, hi, good afternoon. My name is Nancy Kalinoglu, and I am the Director of Claims and Risk Management for City Underwriting Agency, which is an Actuarial partner, and a St. John's graduate as well. I have been involved with claims for over 30 years on the broker side, the carrier side, and the client side.
Thank you, Nancy. Thank you so much. So let's dig into the Pillinger Miller Tarallo Claims Settlement Institute. Our first speaker will be Professor Al Beer, and he's going to be telling us about why insurance companies ignore the claims function at their own risk. The last time we had a conference webinar series, Professor Beer was part of our panel, and he made a comment which I thought was very interesting. He said that insurance companies really don't value the claims function as they should. And that struck me as a little bit curious because, first off, if you have insurance policies, you're going to have claims. And we're all here because there are claims. And as my partner, Jeff Miller, says, we're all in the claim resolution business. So it struck me as a little bit of a disconnect that insurance companies don't value the claims function. So we asked Professor Beer to please come again and give us a little more insight why insurance companies ignore the claims function at their own risk and what can be done about that. Professor Beer?
Tom, thank you very much. Can you hear me okay?
You're fine. Thank you.
Excellent. All right. Well, you gave me an interesting assignment today. Why insurance companies ignore the claims function at their own risk. I will tell you that in preparation, I did deal with a lot of my colleagues and had some discussions. And as you might imagine, there was a lot of pushback, a lot of emotional response. So I will modify the title just a tad, all right? I would certainly suggest that most companies are aware that claims functions play an important role. Very few companies would ignore the claims functions themselves. But I'm very happy you picked that title just to get people's attention, because frankly, the real issue is the degree to which claims functions are recognized among companies. So what I'd like to do is, you've asked me to give just a few short keynote remarks about the, if you will, the state of the insurance claims function. And I guess I'm standing between your audience and the people they really dialed into here. So let me try to be as quick and as proficient as possible. First of all, claims, in my opinion, is absolutely one of the most underutilized strategic assets that many insurance companies have. The better companies understand that, however. Right? Now, honestly, many companies, I would suggest, the basic claims management model is not terribly different than it was 30 years ago. And I'd love for people to challenge me on that, but I think I've been around enough to see that unfortunately, the claims function has not been either progressive enough or been allowed to develop, I think, to take advantage of the strategic asset that it can represent. So what I'd like to do is talk a little bit today about what I see in the industry, and maybe I even will be bold enough to make some suggestions as we go on. So the bottom line, in my opinion, is in the less enlightened companies, claims function is much too often looked upon as the back office. Right? You know, the bad news department, it's where money goes out the door. And as a consequence, I think those claims departments are often near the top of the list when companies try to reduce headcount under the guise of increasing operational efficiency. On the other hand, I think the better run companies recognize claims function as a critical strategic asset. And that's what I'd like to spend the next few minutes talking about what that difference is. Very simply put, I think the difference is treating claims as either a silo or a critically important component of the company's value proposition. What you've got to recognize, in my opinion, is that claims professionals are a rich source of data information. And that information has to flow into the entire business process and making business decisions. Now, why do I feel so strongly about this? Let's talk about a couple of examples. Claims function acts as a critical early warning system of changing and emerging issues. Unfortunately, I think that knowledge goes untapped often for years. So let's pick up a classic example. Today, you cannot listen to an earnings call. You can't go to a management meeting. You certainly can't read an insurance publication without hearing social inflation as some type of recent phenomenon. Anyone who's been in this business for a while is fully aware, for example, commercial auto issues have evidenced themselves, in my opinion, over the last dozen years. We've all seen that. What I enjoy about this particular conference is this audience has had a front row seat watching personal injury and sexual assault liability grow into $1 trillion business over the last few decades. So social inflation per se is no recent phenomena, but yet why has the industry been so hesitant to recognize it? Underwriters, for example, recognizing CTE and other brain injuries exposures, you know, that recognition came years after the initial claims began arriving on claims department doorsteps. To me, that was just evidence of the poorly performing companies and that gap between what was actually being experienced. It's just phenomenal to me how many companies have completely overlooked the value of the information that's being derived out of the claims department. So let's take a look at the obvious. The loss ratio is the single largest component of an insurance company's profitability or lack thereof. So what drives the loss ratio? So let's take a look at underwriting. From a claims department perspective, the claims function can be an unbelievable source of intelligence into, for example, new product development. As I mentioned before, my training is actuarial. Very little, if any, pure actuarial data exists on risks like driverless auto, marijuana distribution, silent cyber exposures. Claims professionals can provide valuable insight into those emerging risks. And even current products, current contract wording improvements are so necessary. And we all know claims professionals are on the cutting edge of identifying unintended consequences of poor policy wording. So to me, the real critical question is, does the insurer's business model allow the claims function to provide that critical feedback? That to me is one of the tests of a fully functioning company. So now let's move to my buddies, the actuaries, pricing and reserving. One of the things that drove me crazy is I've often heard actuaries tell claims people, it doesn't matter whether your process is efficient or not. All that matters is that you're consistent. So that when I put my loss development triangles together, I can basically project into the future based upon stable historical patterns. That is such a, forgive me, selfish concept of devotion to a model rather than a devotion to trying to understand what the future will bring. And if in fact the future is nothing more than a replication of the past, then actuarial models are great. Unfortunately, life doesn't work that way. I happen to chair the audit committees for 2 insurance companies, and I will absolutely not have a discussion on reserving unless we have a claims professional in the audience. Because the subtleties, the qualitative as well as the quantitative issues are so important. I love it when, for example, a claims professional will point out, history's shown that in periods of economic downturns, fraud increases. So if we've got development triangles that are basically the product of a very positive economic environment, they may not be terribly valuable going on into the future, whether it be a workers' compensation scenario where fraud plays a very important part. So just simply blindly applying those factors, while important, there's no doubt that the analysis of historical data is important, but probably, in my opinion, equally important is understand where it works and where it doesn't work. So I love having conversations. We've just experienced Hurricane Ian. All right. How many actuaries can have an intelligent conversation of the effect of assignment of benefits legislation in Florida and how that's going to affect it? Something probably near and dear to a lot of the people in our audience, the impact on frequency and severity of reviver statutes in New York. By definition, they will change the behavior into the future. So blindly relying on simply development patterns, and I am not criticizing actuaries, right? I can get myself in plenty of trouble. I don't need you to get me into trouble, but believe me, all I'm simply saying is shoulder to shoulder, actuaries and claims professionals need to work to make sure they understand those particular issues. Again, I'll raise my favorite topic, social inflation. Everyone, particularly in an insurance company management perspective, can recite the issue of nuclear verdicts. And they can put their slides together basically saying that juries are out of control and plaintiffs' attorneys are being overly aggressive, et cetera, et cetera. But what I enjoy is when my claims professionals can sit down and talk to me and say, one of the most important implications of nuclear verdicts is nuclear settlements. So insurance companies themselves are behaving differently as a result of nuclear verdicts. So even if cases, as we all know in this call, don't go to trial, the actual settlement process has been significantly affected by nuclear verdicts. So the concept of nuclear settlements, again, would have a dramatic impact, in my opinion, on the future. And virtually any actuarial conference I go to, there's 2 or 3 sessions on why we have to modify historic data if we're going to project into the future because of these changes. So put very simply, if you're looking for some very simple anecdotes, your chief actuary, your chairman of the board, your head of your audit committees, somebody needs to understand something as simple as why you'd avoid bringing a case to trial in the Bronx, but taking the very same case and have no trouble putting it in front of a jury in Westchester. To me, that's just a classic example of claims professionals' experience and expertise having an impact on underwriting, on pricing, on reserving. So again, the reason I bring up those anecdotes is I think it's important that our audience understands that they can have an important influence on those very, very critical financial decisions.
Thanks, Al. Nancy, let me just interject for a second. Do you find from the claim side that some of these decisions are taken into effect when you're discussing it with your companies in terms of the claims and what Professor Beer is mentioning?
He's right on target, but I have seen a development lately where the carriers, the underwriting and the loss control are now relying heavily on claims. They're asking for claims opinions. They're working towards trying to figure out where an open claim is going to end up. And but this is new. Loss control employees are now making decisions on whether or not to write an account, and they hadn't been involved. Their job was strictly to go out there and make sure that things were running safely on a job site or at a manufacturing plant, whatever it would be. But now they're actually telling the underwriter, this is a safe account or not, and it's one that we should take on or we shouldn't. So Professor Beer is right on target that the claims professional is the low man on the totem pole because the money does go out. But on the other hand, we drive the whole industry.
Thank you, Nancy. Now, Jack, Professor Beer, do you see this as one of the consequences of this environment where there's a lot of claims and, social inflation, social negotiations in terms of settlements, that the claims are now being included more and more in the decision-making process from the insurance companies?
I'll repeat, I definitely think the better companies are. One of the words of advice I would have for our audience is if you're in a company that perhaps isn't best practices at this particular point, listening to this discussion, talking to some of your peers and understanding that claims can have a significant impact, not only on claim settlement. And Nancy was a perfect lead into the concept of risk management. I mean, how many people recognize that claims can be involved in helping prevent losses? Claims can be involved in loss prevention and loss reduction, which can do nothing more than solidify a relationship between an insured and an insurer. Let's face it, the elimination of a loss is beneficial to both of those particular parties. And I think historically, claims has not been, I'll use the term, allowed to become involved, or people have not recognized, getting back to the title you've asked me to address, basically management has not recognized the ability of claims to provide value there. And I think it's a significant value.
Professor Beer, are there any insurance companies that you're familiar with where the claims people are actually, part of the upper management, the CEO or the president or something like that, where maybe the model is inverted?
That's a great question. I have to honestly say I've asked that question. I have not come up with someone who's necessarily come up through the claims process, and I'd love if there's anyone in the audience who can disagree with me, that would be great. Frankly, I think that speaks volumes to the fact that one of the points that I am trying to make is that claims individuals have to become much more involved from a strategic perspective in insurance company management. If I may, and I've used this speech, if you will, to my actuaries, the second biggest problem is that claims professionals are not being invited into the boardroom. The first problem is that claims professionals are just fine with that. That's got to change. There's got to be a proactivity and I think there's a receptivity, as we just talked about, that the insurance companies are willing and want that type of advice. They're just not particularly aware of it. And I think, frankly, claims professionals can be a bit more proactive to get themselves more involved at the management and board level.
Professor Beer, is that the solution, that claims professionals have to take a bigger jump and a bigger step in terms of making their presence known and their importance known so that they get access to the decision making and become part of the decision makers?
Sadly, I think that's the state of the environment, if you will. I think for the very reason you asked the question about senior management involving, or more importantly, C-suites involving claims individuals, I don't think the industry as a whole is as receptive as it should be. Part of that problem lies with the industry, but as I said, to answer to your question, I think claims professionals can and should be more proactive. And I think they'd be very pleasantly surprised at how receptive management would be if they became more proactive.
So we can use this as a call to action to claims professionals to step it up, pick up the game, and get more involved and be more part of their companies.
Precisely.
And I want to thank Professor Beer, because that was certainly informative. And as I thought, it's provocative, because it really is a call to action to all of our insurance claims people that it's time for us to kind of step up and take our seat at the table and let our voices be heard. And now we're going to have from various, I would say, insurance experts here, we're going to talk about a few things. The first thing we're going to have is Jeff Miller will be talking about 5 mistakes plaintiffs make settling cases. Now, Jeff is one of the top defense attorneys in New York. and he has tremendous experience settling cases. In fact, the Office of Court Administration asked Jeff and Mark Pillinger to teach attorneys how to mediate personal injury cases as part of the OCA's new emphasis on mediating cases early in the litigation process. And Jeff has tremendous expertise resolving cases. I know, for example, an insurance company came and asked him to mediate 25 cases. And he mediated the 25 cases. He settled 24 out of the 25. The 25th case settled after the co-defendant went back and got more authority. And that's not just a one-off kind of an experience, but Jeff does this all the time. So I wanted to ask Jeff to please tell us, based on his experience, what are 5 mistakes that plaintiffs make settling cases? Jeff?
Okay, thank you, Tom. Obviously, Joe Donahue on this lecture team with us and his firm do not make these mistakes.
We're all coming from the mistakes we made, Jeff.
No. But many, they're a top preeminent premier firm. But there's a lot of people out here, and Tom said it earlier, that really just don't get that we are in the resolution business. These cases come, they've happened already. Obviously, safety and all of that is super important in training before these things happen. But once the accident happens and it comes to us, it's a lawsuit already. And our main focus is to resolve the lawsuit. And whether it's through settlement or it's through a trial or it's through motion practice, everybody on both sides of the coin want this case settled. And sometimes the plaintiff's attorneys don't understand that the carriers, as tough as some of them can be, they all do want settlements. They crave resolution. They crave closing files. So don't be scared off by a low offer. Don't make an obscene demand that's going to have a carrier not respond to it. I know Judge de Blasi will talk about, forget the offer, forget the demand. We're negotiating. We're trying to move a case. So for trying to resolve cases, knowing that 98% of these cases settle pre-trial, and the 2% that go to trial, 70% of those settle during trial. The quicker you start the high-low game, the quicker you start the negotiations, the better off you're going to be. You know, sometimes the carriers are looking on the lower cases, but we have a lot of programs where we've settled cases, including with Joe's office, pre-depositions in a heavy construction case, even a 7-figure construction case. If you know, whether it's a labor law case, if you know the risk transfer is resolved and who's left holding the bag, and you have sufficient documentation from plaintiff's counsel to evaluate the case, that case can be settled. There's no point in doing another 2.5, 3 years of discovery, allowing not Joe's office, but other plaintiffs' counsels to get additional surgeries that not necessarily aren't part of the case that comp is going to pay for. The quicker you move this, the better. So it's important. And the carriers really don't want to pay the defense counsel. Carriers don't like paying defense counsel. Trust us. So if they have an opportunity to close a file and not litigate, they will do so. The second point, there's no cavalry coming. You have to do it yourself. We've seen, and it's getting better, but we've seen the reduction in court personnel since COVID. It's been way better in the last 6 months. Things are picking up, trials are starting, etc. But it's not the same. It's still not the same. There's still a tremendous backlog. There's still a delay with the reduction in judges, the court personnel. So in the past, where a judge like George Silver would take the time in court to pull you and spend 2 hours, they just don't have the time to do that anymore. So those days are gone. So if you're going to get these cases settled, you got to do it yourself. We have people like Joe's office and, Evan Sachs or Ken Halpern and at Wingate who reach out to us and they say, hey, we got this case, let's move it. That's part of the relationship business. That's part of what we're trying to do is resolve these cases. So you got to take it upon yourself. And if you're dealing with a tough office, and I'm not going to name who they are, but and I don't mean tough because obviously there's not many tougher than Block O'Toole, but when you have a plaintiff's office that is known as a high volume, low quality, tough to get in touch with office, you gotta be aggressive. You gotta do it yourself. You gotta call Mark Linda 5 times a week and you're gonna move the case with him, but he's not calling you back. So keep on it. It's important to be doing it yourself because nobody else is gonna be pushing to get it done. It's all on yourself to get it done. And then people talk about it may be too early or too late in a case. Never too early, never too late. We spoke about the programs earlier that we're doing quarterly mediations on. We're scheduling cases before depositions. You know, there are times that a case comes into the office and we roundtable all of our cases. There are times that a case comes into our office and somebody's like, we can't put a number on it, it's too early. The truth is you could put a number on anything at any point in time. You may not have sufficient information to be at that end result, but based upon what you have at the present time, you can always evaluate a case. So it's never too early. In regards to too late, there's no such thing as too late. As our partner Tom likes to say, these cases aren't like fine wines. None of them get better for us. They don't get better for the defense. Unless it's a rare exception, it's not too late. We settle cases during jury selection. We settle cases at trial. We settle cases while the jury is out. It is never too late. I interned for Judge Donson, Michael Donson, forever ago. And his famous saying was, do you want 6 clowns in a box deciding what this case is worth? I mean, we're in this business. As much as we can agree to disagree at times on value, industry people aren't going to give the astronomical numbers or the stupidly low numbers that you may get from a jury. It's just a true crapshoot and a roll of the dice. Obviously, preparation and facts and law come fully into it. But we've all experienced crazy jury results. So it's never too late. We've had cases where we do high lows. We're in risk management. We're managing the risk. So during trial, plaintiff may be here, we may be here. Rather than letting the spectrum be this, make it this and get into a high low and manage your risk. It's never too late to settle. Carriers hate those oldest cases on their loss runs. If Nancy's calling me up and saying, why is this case 5 years? Hopefully I can say there was a bankruptcy or a death and there's some kind of stay or something happened. But the carriers hate those oldest cases on their pending. So just get rid of them. It's always right. And
Jeff, let me interrupt you for 1 second
Sure.
here. Now, there is a perception, and plaintiffs will tell you, you know, an insurance company won't give you the best offer until the very end. Therefore, it's better to wait because they don't get serious until we're at the very end of the process. So I'm not going to get serious until they get serious. Kind of a standoff. Obviously, there's no truth to that, correct?
absolutely correct. Here's the deal. You guys will get my Tony Montana. You know the game, Mel. You go high, I go low. This is what happens. It's a negotiation. The carriers want to close cases. They're not waiting to make their best offer on the steps of trial. They're not. They may not make you their best offer at the start, but they will continue good faith negotiations to try to resolve something. So they're not holding on to waiting for the end to pay you because they'd rather pay you earlier and not pay us.
But what about the situation where the plaintiff says, you know, I have to sit down and I have to formulate a demand. I haven't had time. I don't know what to do. I don't want to undervalue the case because then my client will, get mad at me. Is that a realistic concern from your perspective and based on your experience?
We do see, that is also a great question. We do see plaintiffs' offices that do take that position. When that happens, we would call a senior partner over there and say, hey, look, we're trying to move a case. Somebody's saying you're not ready to formulate a demand. Other than a true waiting on a medical procedure and waiting for approval for a surgery or waiting for a surgery to be conducted before being able to formulate a demand. But we were at a mediation 2 weeks ago on a habitational program, silly trip and fall. And it wasn't even a six-figure case, and plaintiff's counsel sent in a kid and they came in and they were like, we've got a 450 demand. And the carrier's like, let's close this one down. I was like, hold on, let's wait. And at the end of the day, this kid had no clue what was going on. We went to the senior partner the next day and said, hey, look, they were there in good faith to settle this case, and you guys really weren't ready. They were upset with the fee they paid, but maybe we can move this now and it would still be a salvaged matter. If took a look at the file, gave us the demand, we closed the case. It was post the mediation, but 72 hours after. And when that happens, you got to just drill on them. They have enough information to make a demand.
So basically, every case can be resolved as soon as you've got enough information to
No
get the
question.
decision-making.
No question. And the fact of the matter is, one of my old mentors and Jeff Schulman's uncle, Jerry Director, taught me when he lowered his bifocals, the best case is a settled case, lad. And it is. The best case is a settled case, because you know what? Nothing can go wrong anymore other than not getting the check on time. But the best case is a settled case, and everybody wants resolution and they want to close cases. Everybody wants to take it off their loss run. Everybody wants to get it off the desk. And more often than not, you settle a case, you get a new case in because they appreciate your work.
Thanks, Jeff. Those are extremely useful and practical information. I think that if people follow those points, it'll go a long way towards improving the resolutions and the quality of resolutions, which is one of the things we want to do today with our Claims Settlement Institute. We want to take information from people who have hands-on experience, such as yourself, and we want to be able to refine this so that our stakeholders, so that like-minded people from plaintiffs, defendants, insurance companies, mediators, claims, judges, we can take this information and we can add to the advance the art and science of settling cases, because it is an art and science, is it not?
No question. A good combination of a little art and a little science.
Thank you very much.
Thank you.
So our next panelist is Joe Donahue. Joe is one of the top plaintiffs' attorneys in New York. He's with the firm Block, O'Toole and Murphy, and he's going to be talking about 5 mistakes that defendants make settling cases. Now, Joe is a tremendous attorney. He has over $100 million in verdicts and settlements, and he knows how to try a case. He knows how to take a verdict on a case, but even more important is he knows how to resolve cases. So we asked Joe to please tell us about 5 mistakes that defendants make when settling cases. Joe?
Thanks, Tom. I really appreciate it. And again, thank you for inviting me. And I want to start by saying that, Jeff made some really tremendous points and spot on. We are, and plaintiffs agree, we are in the resolution business. Clients are not happy until the case is resolved. They want finalization so they can move on with their lives. And, Jeff made a lot of really great points when it comes to things that I think plaintiffs need to do better. We're always striving to do better for our clients. And some of the things I'm going to talk about, 5 mistakes that defendants make when moving towards a resolution and trying to get a case resolved, I think they're applicable to plaintiffs as well. So they're not just really, I'm not just picking on you defense guys. They're really applicable to both. And because we're in the resolution business, what we're both trying to do really is risk analysis. So we're in the risk analysis business, and what a better way to really formulating risk analysis, then do what you need to do. And the first thing is reaching out to plaintiffs' attorneys early and often with respect to resolution. Okay. You know, and we have cases with Jeff's office. And one of the things that I enjoy about, you know, working with, you know, Pillinger Miller Tarallo, a great law firm, is the communication. What you want to do is, number one, develop a relationship with your colleagues. You know, I know we're in the litigation business, and you can advocate for your client without being adversarial towards your colleague. So first and foremost, you have the ability to speak to your colleague early, develop a relationship so there is some free-flowing information. Because in order to really develop risk analysis, you have to get as much information as you possibly can. And one of the things as a plaintiff's lawyer that I'll do, if you're a defense attorney on my case and you call me, I will give you all the information that you ask for. Anything that you want to know about my case, I'm going to tell you, and I'm going to tell you as soon as you're willing to listen. And the reason is because then I'm able to give you information that's going to help you analyze not only your case, but analyze the position that I'm taking on the case. And isn't that important? Because whether you're a plaintiff or defendant, you want to not only understand your position, but how can you possibly perform good risk analysis, solid risk analysis, unless you understand the position that your colleague's taking. So really speak to the plaintiff's attorney early on, get as much information as you possibly can so you can have a good working understanding of the universe that you're dealing with. And as Jeff alluded to, the plaintiff's attorney might not have all the information at a given time. There might be ongoing medical treatment, so it might not have answers to all those questions. But in terms of calling a plaintiff's attorney and that person not knowing the value of their case as it exists at that time, to me is inexcusable. So also in having those early communications with plaintiff's counsel and ongoing conversations, when you get an understanding of the position each one of the sides of the ball is taking, it's also going to reduce the amount of posturing, the silly posturing that keeps us away from resolving a case. And I think then you can start having some real conversations with plaintiff's counsel, with defense counsel. And if you look at it, most of the time, when you start having those real conversations, the gap that separates our disagreement in those final resolutions, those final numbers, they're usually, I'd say the majority of the time, it's a small gap. It's not a large gap. And if you develop that relationship over time and that trust, you can really get down to developing where that small gap exists, which is going to move the case towards resolution. You know, the second point is, and I think this coincides with what I originally said, is don't adopt a hostile attitude towards plaintiff's attorney or their claims. This isn't personal. These are claims. Claims are being made, defenses are being asserted. And, you know, we're in the litigation business. It's stressful enough, but there's nothing worse than having a hostile relationship with your colleague. It's not going to benefit your case. I can tell you from start. And I think everybody knows that. Having an adversary who's going to make your life more difficult isn't helpful to how the case is litigated. And quite frankly, isn't going to be helpful to reaching, you know, an amicable resolution. So, you know, to the extent that you can have a working relationship with your colleague on the other side, you should do so. That's the way we try to conduct ourselves here. I know it doesn't always work out. People get frustrated or get lost in the moment, but always come back and say, you know, we can have a good working relationship with each other, because at the end of the day, that's what's going to help move the case along as well. The next point is not having gone to the carrier with a realistic evaluation prior to a mediation and failing to manage expectations. And this one really applies to plaintiff's counsel as well. It really does. In order to get to a point where a case can be brought to a mediation, where the parties can sit down and have a good shot at resolving the matter, you have to have a realistic evaluation. And, you know, I recently had a case where I was told that, you know, claims has read the defense reports and The defense reports support their case, and that was the end of the analysis. And I said, well, you know, we have reports too. So your experts are going to come in and you believe in them. And our experts are going to come in and we believe in them. But what we neither of us know is which one the jury's going to believe, right? And that's the problem. And that's the risk that both sides take in just really looking at their side of the table without considering what's been presented to them from the other side of the table. And then when you look at that, then you have to manage the expectations. You know, I hear I'll meet with a new client and the client will have maybe interviewed other lawyers and the client will say, well, this lawyer told me they can get X amount of money on the case. And I'm sitting there saying, well, this accident just happened. So I'm not sure. And what I say to a client is, I can't tell you what your case is worth because there are too many unanswered questions. And as time goes on and you develop the relationship with that client, you learn more information, you spend time with them discussing the facts of the case, the damages of the case, the risk of the case. Then you can have, as time goes on, more concrete discussions to reasonably manage those expectations. And the last time that you want to reasonably get someone's expectations in line with the facts of the cases the moment before you go to a mediation. This is a process that takes place over time to make sure that when you actually get to a mediation, you are in an area where people can have reasonable discussions. Otherwise, you're really setting up the mediation for failure before you even get there. So that's another thing. And that coincides with my next point of failing to objectively evaluate the pros and cons of not settling, including considering interest in post-summary judgment cases. Now, obviously, when you go to a mediation, you want to know the good, the bad, and ugly as it relates to your case. And if you don't know that, you can't properly evaluate it, and you can't properly attend a mediation and have an expectation that the case has the possibility of settling. And I think a lot of times, as plaintiffs, what we consider to be an important factor is if we have interest running. And interest is 9% per annum. And when you look at over the course of time, that number can be significant. You know, here we are, we're post-COVID. There is a huge backlog. Before COVID, there was a huge backlog. So from the time that you got summary judgment, if you're in the Bronx, you might wait 3 more years for trial. That's 27% interest if the matter goes to a verdict and is converted into a judgment. God forbid that jury come back and ring the bell for plaintiff. You're talking about another 2 to 3 years in post-trial motions and appeals. So you could be talking at the end of the day, anywhere between 5 and 7 years of interest that's going to be owed on a judgment. You're talking, upwards of 63%. So it's a factor that has to be considered. And I think that goes right in line with what Jeff was saying of early resolution, because these cases don't necessarily get better for the defense, which leads us to the next point of thinking if the mediation fails that the plaintiff's going to change their valuation and lower their demand and take a lower number. I can just tell you that's not going to happen. It's not going to happen in the cases that I know that we handle. And that's because as time goes on, cases just don't get better for the defense. Clients have complications with their medical care and treatment, and they require more surgeries. That can happen. Cases linger, there's interest running, costs of defense. Cases aren't going to get better. And plaintiffs know that. And when a mediation fails, they're not going to go back and say, oh, it failed, so let's just basically forget what we were talking about, settle for a much lower number. It's just not going to happen.
Joe, Jeff Miller's favorite saying is that cases are not like wine or cheese. They do not age well. So we echo that for sure. Can I interrupt and pose this question to you, Joe? It came from the audience.
Absolutely.
Okay, so this is a question about pre-suit. You get a case in, you've performed some type of evaluation, and it goes to the insurance company. Maybe you send a notice letter, and claims rep tries to get a hold of somebody in your office. And instead of getting, Joe or, Donahue or Jeff Block, they get a paralegal, an administrative person, and they can't reach someone who potentially has authority to resolve the case before they even call PMT or another firm to represent the defendant. How do they do better in communicating with plaintiffs' firms to get through to your office or a plaintiff's office like yours?
Right. And it's interesting you say that, because I've never not taken a call from an adjuster ever.
And you guys are great. It's probably not the best question for Block 02,
Right.
But be persistent. Get the phone number, get an email, make it such that they cannot ignore you. That's the best thing to do. At the end of the day, because plaintiffs are in the resolution business as well, if you get on their radar screen, there's no reason for them not to call you back. So I would just say be persistent. If you speak to that paralegal, when is Joe going to be back in the office? Do you have his direct line instead of getting steered towards a paralegal or an associate? When you speak to whoever, whether it be a paralegal or the office secretary, hey, does Joe have an email? Can I have his email address? Are you permitted to give out cell phone numbers? I mean, at this point, I think I speak to my colleagues more on their own cell phones than I do on their office lines. If you're willing to, leave your cell phone so you're not missing a call, if you're not in the office when you get back. But be persistent. Send a letter. Letters can't be ignored. When a letter comes in, somebody's going to look at it. So emails, phone calls, letters, cell phones. Be persistent, and somebody will call you back.
Joe brings up a great point, and you don't get that when you're calling Block and O'Toole. But in some of the other offices, and I agree with whoever question it is, it can be difficult. I'm very easygoing. It drives me crazy when I'm calling somebody that I don't get a call back. I will call, and you just said it, persistence. I will call 2 times a day, or at least, without being annoying. I'm not annoying the person who's getting the message. I said, look, I've called Mr. X 5 times in the last 7 days, and I haven't gotten a call back. Would you please convey to him or her to please have the professional courtesy just to return my call, please? And I know it's not your fault, but like you just said, you got to be persistent. And I know it doesn't really happen in your offices, but there are offices. And even myself as an owner have called other offices with owners and said, would you please have so-and-so call me back already? This is getting a little silly. I have a client and they want an answer and I can't give it to them, and it's making me look bad now. All I want is a simple call back, please.
It's a great point. It's a great point. The last thing I did want to say is just at the mediation itself and mistakes that I see really from both sides is it, and Jeff alluded to this before, it doesn't matter where you start. In other words, somebody says, no, the offer is too low or the demand is too high. It doesn't matter where you start. It matters where you end. So, be patient, see the mediation through, keep talking, keep increasing your demand, lowering your demand, increasing your offer. Don't walk away, and don't think in your presentation at a mediation that you're going to change the mind of the colleague across the table. And that's not what you're trying to do. What you're simply trying to do is present your case and hoping that they consider some of your points in their evaluation of the risk. But don't come into that mediation overly aggressive, thinking that you're going to change the minds of people, and be really patient. And I think that's kind of my last point. I think that what would make mediation successful from both sides, and I'm sure Judge de Blasi will correct me if I'm wrong on that.
Those are great points.
Thanks,
And I
thanks,
love that
Joe.
guy.
We've got another interesting question about mediation negotiation. And it states, when we are negotiating, do we have to negotiate? This person states she would like to just give a fair number and that number be accepted, but it is never accepted. It's always expected a claims handler will negotiate. Maybe Jeff Miller, you want to take this because you quoted Tony Montana and his negotiating skills. But maybe you want to talk about, can you just give a number?
Sure. That's also a great question. And I personally don't have a problem with that whatsoever. And I know one specific claim professional who operates in that exact way. I think the danger is the industry is used to, there's always going to be another offer. There's always going to be another demand. Don't draw the line in the sand. I get it. And I actually like it very much. And there are times that I've told our claims professionals that we're working with, you know what? He's not ready to make a demand. We know what we feel the case is worth. I suggest you make a reasonable offer. And they're always, well, what if his demand's going to be under the offer? I was like, it's not about what they're thinking it's worth. It's a negotiation back and forth, and we're comfortable with what we think it's worth. You can make that offer. And if you're going to take that route, as that question was saying, you just got to make it very clear, because most parties are used to, there's always something, there's always holding something back. But I'll tell you, if you made a straight offer to Block O'Toole and said, look, we're telling you what we think this case is worth, and they think it was a good offer, you can settle cases with them that way. But there are people out there that I must warn you will always think there's more money.
That's a great point, Jeff. Joe?
Very quickly, yeah. And I've had those situations. I've had those situations where, we walk into a mediation and 5 minutes later, the case is done. But I think you can do that. I agree with Jeff that you might be met with a lot of skepticism in the industry. But I think one of the ways you can do that and do it successfully is to have a lot of conversations during the case, which was my first point, with plaintiff's counsel, where you really have those discussions where you talk about valuation and you have a lot of discussions, maybe not offers and demands, but more of an insight as to where each party sees the case and the value of the case. So you kind of get an understanding of where each other are coming from, and you build that trust factor with your colleague that you're talking to. So when that number is put out there, you have trust that that is the number. It's not going any higher. And you'll have maybe more of a comfort level in accepting that number, and that person will have more of a comfort level in putting that number out there based on those prior conversations.
Joe,
If
you
I could
raised.
I'm sorry, if I can just interrupt
Nancy?
a minute.
Sure,
Yes, I just
please,
wanted to add, great point. Joe and Jeff are both making, coming from an adjuster's perspective. If you have those conversations early on with your colleagues and you tell them, this is what I have in my file, this is what I think this case is worth today, and you put a reasonable number out there. I know that I've done that, especially if I know my colleague and they know me and they know that I'm putting a fair number on a case. You can settle a case, because you have to remember, everyone always talks about how defense costs continue, but I'm sure Joe would agree that the longer a case stays in his office, he also is going to start taking on more fees and more expense on keeping that case. He's got to pay someone just to keep looking at that case. So there's that motivation to settle. And I'm sure that Judge de Blasi is going to talk in this too. But again, it's very important for adjusters to know, pre-suit, in-suit, doesn't matter. At any given day, a case does have a value. The value might be zero, but the case does have a value. And if you call and discuss why you think where you're at and why you see the case this way and find out the other side's perspective, it'll make your cases settle much more quickly and really at a number that everybody can live with.
It's a great point, Nancy.
Yeah, and I'm going to say, I've seen Nancy do it firsthand. And she walks in that room and she means it. And people have learned that. And I know she's got relationships with some of the biggest, heaviest hitters on both sides of the fence. But when she says it, she means it. And you've created that reputation already, so you're able to do that.
So I think one of the things we're really getting at here, and this is a great discussion, is that it's about communication. And it's about communicating with the adversary, communicating with your internal insurance company, communicating with the client. Communication helps pave the way for a resolution. Because once you're communicating, you're able to find the common ground and move off of the grounds that are not working. And now we'll move on to our next panelist and our next discussion. Judge de Blasi will be talking about 5 mistakes every attorney makes during mediation. Judge de Blasi is a retired Supreme Court justice, and he's a neutral at national arbitration and mediation. He scores at the top of the list every year in terms of the most respected mediators and neutrals. And it's not that he mediates cases just in New York, but he mediates cases nationwide. So he has a depth of experience and knowledge, which is truly terrific for us to tap into. So we wanted to ask Judge de Blasi to tell us 5 mistakes that every attorney makes during mediation. Judge?
Thanks, Tom. And I guarantee you I could also talk about 5 mistakes that every mediator could potentially make during the course of a mediation. We are not perfect. We make mistakes. I pride myself, having done this for 15 years, of trying to learn from each mediation that I do. And particularly, it's fascinating for me to listen to my colleagues here, talk about the topic, because I also feel that I learn from them on a daily basis. They probably teach me and inform me as much as I hope I teach and inform them. But, repetition is a great teacher. And I spend typically exclusive of preparation about 100 hours a week negotiating cases. And it's not that I'm any smarter than anybody else, but when you are doing something that frequently, you see patterns emerge. And the 5 things that consistently emerge, and this does not apply necessarily to one side or the other. And of course, I'm a mediator, so I'm going to be right down the middle. You see common mistakes which occur on both sides. Failing to know who your adversary is. And Jeff touched on that when he was talking about who he was negotiating with at a mediation, why it failed, and then why he was able to resurrect it thereafter with the right person. Failing to disclose information that could potentially affect the evaluation by one side or the other with respect to the settlement value of a case. Being a moving target, this is really one of the worst ones with respect to demands and offers. The compulsion to repeatedly argue over and over the facts of the case as if you were trying it, rather than focusing on the reason that we're there, which is the negotiation itself. And I know Joe was talking about that. We're there to negotiate. You mentioned that it's a negotiation. That's what we're doing. We're not trying the case. And then finally, failing to use the mediator to your advantage during the course of the mediation. When I think about failing to assess your adversary, and I can settle cases for $100,000 or I could settle cases for 8 figures. It really doesn't make any difference. The principles become the same. But I had one case where I walk in and at the mediation, the demand is $125 million and the initial offer pre-mediation is $15 million. And we go through the joint session, and there are approximately 20 attorneys and claims professionals in one room and 6 plaintiffs attorneys in the other room with lead plaintiff attorney. And the group looks at me after chatting for a little while and says to me, "Who is this guy?" I said, "Who are you referring to? Who's this plaintiff's attorney?" Well, you would think walking into a case where you have a demand in excess of $100 million and you've already put $15 million on the table, that you would know that this attorney tries cases all over the United States, all different types of cases, and routinely hits for nuclear numbers. And that's the basis for the demand. And you have to know who you're dealing with right off the bat. That's just simple due diligence. And it doesn't make any difference whether it's a case of that value or it's a $500,000 case. Who are you negotiating with? Do they try cases? Okay, so Block and O'Toole, I know they will try any case. Jeff will try any case. I know you will try any case. There's no doubt in my mind that if you'll go to the mattresses, as they say, if you have to. You don't want to. You want to resolve the case, but you're not afraid of trying a case. That factors into a negotiation. In the majority of times, will know which firms do try cases and which firms do not. Is the plaintiff's attorney going to give out the case if they can't settle at a mediation? That radically affects the negotiating position of the defendant during the course of the mediation process, because they're going to have to give up a substantial portion of their fee to give it out to trial counsel. And then the trial counsel has to exceed a certain number on a verdict in order for them to make it worth their while to give it out. And the same, and going back to what Jeff said, which is so important, who am I speaking to? Is the person that I'm speaking to the person who actually has the authority to settle the case? Is the person that I'm speaking to the person who's actually going to try the case and make the decision as to whether this case is going to settle or not? Is this the type of firm that will get ready to try a case, but they're always going to settle the case immediately before or during jury selection? They're going to fold, in other words. Hate to use that word, but all of us in this room know there are firms that fold. Do they prep their case properly? I know with the good plaintiffs firms, if they are pushed and they have to prep their case, they'll be saying to me during the mediation, "Hey, John, we got to line up our experts and we're going to have to start paying them. We're getting ready for trial." By the same token, I know that type of firm is dangerous because they are going to get ready and it's going to affect their settlement value going forward. Whereas there are other firms, if you know their background, that they're not going to get ready. They're going to wait until the very last minute to retain an expert only if they have to. Does the firm mediate cases on a regular basis? There are law firms that have attorneys who are designated to do nothing else than mediate cases, and I know them, I work with them, I know their negotiating style. However, there are many attorneys who might be mediating a case once a year. So I'm doing it 100 hours a week, they're doing it once a year. How does that impact on the process, and why should you know that? If they're mediating a case once a year, in the majority of cases, they don't even understand the mediation process, and it becomes problematic during the course of the negotiation. And I think we were talking about whether someone comes right out there and puts out a number or engages in what I call incremental trench warfare, where you go back and forth multiple times trying to get to a number. And by the way, I might say that the benefit of that, not necessarily that I believe in an incremental negotiation, I like the negotiations to go faster. Everybody's doing their due diligence. Everybody wants to feel that they did the best for their clients. So I understand as a mediator, listen, I could probably do this in 3 steps, but it may take 15 for everybody to have the confidence to feel that they got the best result for their client. But again, the last thing is, what is their negotiating style? How do you gain this information? It's pretty simple. You can go out on the internet and look somebody up and find out what their background is, what they do. You can go to a jury verdict reporter, find out how many cases they try. Or in a situation where you're in an insurance company or on the defense side or on the plaintiff side, you can ask your colleagues, have you tried cases with them? Have you mediated cases with them? What's their style? Do they try cases? How do they handle themselves during the negotiation process? Failing to disclose information prior to the mediation, which will affect the evaluation by the other side. This goes both ways. This morning, I had a mediation. Fortunately, we settled the case, and I had to write it down. I have some of the information. I have some information I did not previously exchange, and I hope that doesn't change anything. Okay. When I hear that, that's like throwing a time bomb into the mediation before we've even had the joint session. And of course, what were we dealing with? And I'm not laying this all on the plaintiff's part. It goes both ways. Lien information, okay? Lien information. I don't know how many times I suffer from heart palpitations when I hear the plaintiff's attorney say, "We just got an updated lien amount." I'm going like, "Oh, great." Now the defendants are saying to me, "We thought it was a $50,000 lien. Now it's a $400,000 lien, and they have a case cash lien on top of that." It's a problem. So, if you're a plaintiff's attorney, obviously you should be disclosing this up front. If you're a defense attorney, you should be doing your due diligence to the best of your ability to try and assess, and make sure you have the right lien number. By the same token, the amounts of coverage. I had a case the other day where the defendant said to me, "Well, we only have $1 million policy." I go back and I speak to the plaintiff's attorney. He says, "Yeah, but there's $7 million in excess." I go back and I speak to the defendants. I said to them, "Well, the plaintiff's attorney's telling me you got $7 million in excess and the demand is $4 million. Well, we don't have it." And I said, "Well, you don't have it. Does somebody have it?" "Well, yes, we believe there is excess." "Do they know that the mediation is taking place?" Well, we sent them a letter. Well, the bottom line is that you should disclose, because of course, at that point in time, the plaintiff's attorney is saying, I'm not negotiating against the primary policy. And had I known only the primary policy was going to be present and there was not going to be an excess carrier, we wouldn't have mediated this case. Disclaimers. This is a great one that I've seen on the defense side. I don't know if it's a tactic or just a mistake. You get into a mediation, you have somebody who's a major player on the defense side of the mediation. I never forget, I had a room with 16 people in it, and the defendant, who's one of the primary targets, defense counsel says, oh, my carrier disclaimed last night. Okay, so now you have 16 people there. One of the main players who's going to have to pay now tells us all that there was a disclaimer last night. Well, it could be a disclaimer at any time, but if there's a disclaimer or a reservation of rights, you really should tell the other side in advance, because it's going to affect not only the plaintiff's evaluation of the case, it's going to affect your co-defendant's evaluation of the case. And then any other evidence, documents, witnesses that are going to radically affect the case, you should disclose it beforehand. Some people say to me, well, tactically, I don't want to disclose that. And I said, well, tactically, how do I go and explain to the other side that you want this much money without that information? I said, it's great that you want to hold it back for trial, but I can't get you the money you want, or I can't get them down unless I have that information and I'm in a position of disclosing it. Being a moving target, this is the worst. I hate this. Happens on both sides. Everybody shares equally on this one. I have a plaintiff's attorney who comes in, says, well, we demanded $1 million pre-mediation, but our offer today is, our demand today is now $4 million. Or I have a defense attorney who says, well, we had indicated that we had, $300,000 or $400,000 on the case, but in reality, we don't have that. Well, the bottom line is that should be something that's disclosed in advance if there's going to be some type of significant change. Also, during the course of the mediation, I've seen this happen on both sides. Well, will the plaintiff take this number? Well, will the defendants pay this number? Now, when I was a young, less experienced mediator 16 years ago, I was very trusting, and because all of us would assume, well, if you're asking me, would the plaintiff take this number or would the defendants pay this number, you would either pay or accept that number if it was on the table. And then you have the person turn around and say, well, yeah, but we don't have anywhere near that authority. Yeah, no, we don't have anywhere near that authority to accept that type of number on behalf of our client. Drives me crazy, and you can't do that. The other thing that's very, very common and is a major problem is there's a disagreement as to what the settlement negotiations were beforehand. I will tell you, not anecdotally, I will tell you statistically, 95% of the submissions that I get describe the pre-mediation settlement discussions, and they are completely inapposite. They do not agree. Defendant offered $400,000, indicated they would pay $6. Plaintiff said he would take $4 on the case. And I'm looking at it saying, okay, we have a problem here right at the get-go. So, what's the way to resolve this? You have to have, and I don't know if it was Joe or Jeff who mentioned this, you have to have some form of communication with the other side with regard to these issues beforehand, or have no communication with them. Don't start discussing settlement before it gets to me, because then the first battle that I have to mediate is what happened before the mediation, and how am I going to get these people to become less contentious because they're now fighting over what was said before the mediation ever commenced. The compulsion to repeatedly argue. This is a big mistake. I see this all the time. I do the joint session. I've heard everything. I've read the submission. I go into one room. They repeat everything that was said in the joint session. I think it's like many times I'm like a therapist. I have to hear it. I go into the other room. They repeat it all over again. Now, I'll separate that out from speaking to clients, because I love speaking to clients, because if I speak to the client many times and they get what they have to say off their chest, that will facilitate the settlement. And I love to do that. I'm happy to do that if the party's asking. But we're going back and forth, and all I'm hearing is argument, the same arguments I've heard 6 times. It's like when I was on the bench, because when I was on the bench, though, I could say, stop, I don't want to hear this again. I can't say it in a mediation. What I diplomatically say is, okay, well, I get all of that, but what is your offer, or what is your demand, or what is your response? There's just this tendency to fixate, and lawyers fixate on the points that they want to make and how the case would be tried, because they want to convince me of something. And ultimately, you're not going to convince me. And I know it was discussed, it's not about convincing one side or the other as to what the right number should be based upon the facts. It's about this negotiation process that moves forward, and which is really the process of gaining acceptance on either side, and both sides feeling comfortable that they made reasoned compromises that were in the best interests of their client. The last thing that I'll mention, which is a mistake that's made all the time, is not seeking my assistance, not seeking the mediator's assistance. It's very simple, and many times I'm sort of amazed at it. I'm sitting there with a thought in my mind as to how this case could potentially settle or what my evaluation is of the case, and nobody's asking me. I've learned over the years to wait. Eventually, most people will ask me, but eventually, if they don't, I will give them my evaluation of the case when I think they're ready for it, because a lot of times they have to feel that they're heard, their arguments are ratified, their reasoning is ratified before I give the opinion. But you should use the mediator to get some form of evaluation with respect to a multiplicity of issues in the case. A lot of times, as a former judge, attorneys will say to me, what do you think of the appealable issue with respect to the decision that was rendered by the Supreme Court judge? What do you think about this issue on appeal? What do you think about this issue with respect to admissibility at trial? And actually, one of the things that's now coming up that people are asking me is, what do you think about the Grieving Families Act that's before Governor Hochul? We have a wrongful death case now. We have an 18-year-old who was killed, and I had this case just recently, in an automobile accident. Plaintiff has good liability. The case by itself, without conscious pain and suffering, would not be a big number case. However, when this legislation passes, which is going to grandfather in every existing wrongful death case, that case now has a situation where you have a mother, a father, and 3 siblings. We have no idea how much each will recover. We have no idea what sustainable value is. But the point is that, what I'll say to go, to a defendant's office when they're telling me, well, the case is only worth $225,000, I will say to them, well, how about the Grieving Families Act? I've had many defendants say to me, what's that? And I said, well, it's on the governor's desk. It was passed by a bipartisan group of both assembly persons and senators, and it's going to be signed at some point. It's not going to survive a veto. In addition to getting the evaluation of the case, the last thing I'll say is I find that many attorneys will ask me at some point, well, how do you think we should best negotiate this? Well, you don't have to listen to my evaluation, and you don't have to listen to my advice on how you should negotiate a case. And I never, assume that I know any better than anybody else, but I'm a good sounding board. The mediator is a good sounding board to say, hey, listen, what move should we make next? What do you think of this? How do you think we should approach this? Do you think that this is fatal? Do you really think we're going to be able to get the case settled? What are the ranges that we potentially could get the case settled in? We're never going to pay it today, but where do you think we ultimately might be able to get this case settled? All of those types of questions and many, many more you can pose to the mediator, and use the mediator, I believe, to your advantage during the course of the process to make it more successful. That's it.
Hey,
Thank you,
we
Judge.
we have a specific question related to mediation, and it's for the entire panel. And the question basically asks what we think of brackets. I'm going to just briefly comment that one of the things that I have as a mistake made at mediation is when parties are inflexible. I see it all the time, and you can use brackets as a perfect example when you get an adjuster or a plaintiff who simply, I don't do brackets. And I've had that happen, and it just kills the mediation. Am I a big fan of brackets? Personally, no, I'm not. Have I used them effectively? Yes, it usually won't settle the case for me the same day, but it gives us a good range that we can take back later and in a second round potentially settle the case. Not a big fan, but again, I'm flexible enough to say, okay, well, if nothing else is working that I prefer, I'm open to the idea of brackets. Okay, so anyone else who wants to tackle the bracket question?
The common answer that I get is, what's a bracket? and I hear that all the time. I'll say, well, the plaintiff or the defendant has proposed a bracket of X to Y, and I'll get this response, well, what is a bracket? How do I handle that? What does that mean? They can be used. I mean, I'm not a huge fan of them, only to the extent I do think they're very useful if you're trying to compress numbers. In other words, when you have parties who who are incredibly far apart, and you're just trying to get the numbers somewhat closer. The danger with brackets is this. Let's say one party says, I'm going to say my bracket is between 1 and 5. Okay. So you have a 2.5 midpoint, and it's presumed automatically that the defendant hypothetically would pay $250,000, 2.5 million. A plaintiff comes back and says, well, I'm between 5 and $1 million. Okay. So now there's a presumption that the plaintiff will take 750. Well, that obviously goes to the negotiation strategy that you have to keep this midpoint of the bracket either well above or well below what you will actually either pay and or accept. The problem is, however, though, let's say you have a defendant with a 250 midpoint and a plaintiff with a 750 midpoint. Then what happens is someone gets the very smart, idea, sometimes unfortunately the mediator. Well, what we really have is a 750 demand and a 250 offer, so 500,000 is going to close the case. And that's one of the dangers of brackets. That's how it can play out. So I'm not a big fan, but you can use them to compress numbers.
Yeah, I agree. I'm a fan of utilizing anything to keep negotiations going forward, but there can be a misunderstanding when you're dealing with brackets. Whereas, are you talking about the midpoint being the number? Or are you talking about the midpoint? I think conditional offers are also can be useful at times. At least it keeps people talking and gets people an understanding of perhaps what the other party's thinking, but there can be misunderstandings.
Yeah, that's exactly why I don't particularly like brackets. But again, I think you need to be open to any possibility. And as the judge points out, if you're so far apart on the range, can you at least get some range agreed upon? Because the more you can agree on something and find common ground, the more likely you are that you'll settle the case.
Thanks, Jeff. I want to, I think we're running a little bit out of time for our first session, and I want to thank our panelists for being part of this. You've given us a tremendous amount of useful information, which is exactly what we wanted to have happen, having our panelists take on these topics. We have a great give and take, and I want to thank you for your time. And we have another session coming up where we're going to be talking about the results of our settlement survey. Okay, well, thank you, everyone, and welcome back to our second session of the Pillinger Miller Tarallo Claims Settlement. As I mentioned, our goal in starting a Claims Settlement Institute was to take PMT's 20 years of experience in resolving cases and combine that with like-minded stakeholders from plaintiffs, defendants, insurance companies, claims, judges, mediators, so we could create a vehicle to advance the art and science of settling cases. And we heard from some very great panelists in our first session, a lot of useful information there. And in our second session, we're going to go down a little bit into the, not nuts and bolts, but into the information that we received when we sent out a survey about settlements in 2020 and 2021. It's Pillinger Miller Tarallo and St. John's. We sent the survey out together. And so let's take a look at what we found. Now, we know that 2021 was a very different year than 2020. We know that in 2020, the courts shut down abruptly. There was some activity, perhaps maybe by the end of the year. And we know that by 2021, things were starting to open up. There were more court conferences. There were more in-person court conferences, virtual conferences. So the whole year had a very different feel to it. And one of the things that we wanted to know was, did the reopening of the courts, did that make a difference in resolving cases? So let me first ask Jeff Shulman. Jeff, you're the managing partner of PMT's upstate offices in New York, Buffalo, and Syracuse. I know you see a lot of cases, you settle a lot of cases, and you also litigate cases nationally. From your perspective, did the reopening of the courts make any difference in resolving cases?
So yes, we're trying cases now. We just took a verdict in Greene County, actually got a defense verdict. But that's always, when you have a real trial date looming, that always puts pressure on parties to settle. which is fantastic. So we're seeing cases move. I will say that, judges are putting 2 and 3 cases deep on the trial calendar. So you may not be the #1 case to go, but the threat is there. It's marked final. So we're seeing that definitely inspire some settlement as we get closer. We're getting toward the end of the year. We have a bunch of mediations scheduled. Of course, we try and push all year round, but there's always that year-end push. So we're seeing that. But we also spoke about this, and I think we might have lectured about this. We saw a lot of settlements during the pandemic. And the question was, are plaintiffs firms discounting cases? Or why are we seeing an increase or a spike in settlements? And we weren't seeing necessarily cases settling for less than their value, but we were seeing some firms incentivized to try and get to the table sooner because there was no looming trial date.
Excellent. John Tambasia, you practice a lot in New Jersey, and I wanted to ask you from the experience that you've had in New Jersey, has the reopening of the courts made a difference in resolving cases?
It has made a difference with certain cases. And I say this with caution because we've talked a lot about the dynamic of how parties carry themselves in settlement negotiations. One of the first ways to get yourself to a settlement in New Jersey is to be unprepared for trial. The courts are definitely calling cases in smaller numbers. So don't be surprised if you're one of 16 and they have 8 judges. Your chances of going out are very good. The party who is not ready will definitely get called and you'll see a settlement. So New Jersey's taking a very, very methodic approach. They're screening cases, larger cases which have made the dynamic of getting on the list. You file an in limine motion, you will get a trial judge. And don't be surprised if after your motion you're said, come in a week later. So yes, we're seeing an increase in settlements. And we're also seeing an increase in trials. So it's an interesting dynamic.
Thanks, John. Nancy, from the claims perspective, did you find that the reopening of the courts made a difference in settling cases?
I'll be honest with you, not really. It helped to move cases, obviously, but not with settlements. Unless the case, the last thing to do was to have a trial, the cases are really not moving. Adjusters are looking for discovery items. So I don't really see a lot of settlements with the reopening of the courts.
Thank you. That's an excellent perspective. And Joe Block. Yes.
We have a VIP in the audience, John McCune, who had a question. Hi,
Sure.
John, out there. John wanted to know about the defense verdict, so I figure I'll give a little anecdotal evidence. So it was a case where a motorcycle operator was driving home from a bar, and he drove into a dumpster that was parked along private owner's property. And we had the company who had leased the dumpster to the homeowner and placed it in the roadway. A lot of different issues present, very bad accident, but the motorcycle operator blew a .18 and was legally intoxicated. We had summary judgment denied. We argued that it was the sole proximate cause of the accident. And the thrust of the case against us as the company who leased the dumpster was, A, we didn't have proper markings on the dumpster, including reflective tape, et cetera. And B, where we placed it created a hazard. It wasn't perfectly adjacent to the sidewalk and the curb line, but it was a curved roadway. So you couldn't possibly place it adjacent to the curb or roadway, curb line or sidewalk. So we were getting ready for trial. We had some expert video depositions of physicians on damages. And then when we picked a jury, we were advised that the judge was bifurcating the trial. So we tried liability only, and we were able to get our client out based on plaintiff's intoxication being the sole proximate cause of the accident.
Excellent. Thanks, Jeff. Let me switch it back to Joe Block and ask him if the reopening of the courts made a difference in resolving cases. Joe?
I think you have to break this down into 2 different subsets. Smaller cases, meaning cases with lower values or limited insurance coverage, and the bigger cases, the 7+ figure cases. Our experience here at Block O'Toole and Murphy is we really didn't have a drop off in 2020, 2021, or this year. Despite the courts being closed in 2020, we settled a lot of cases for what we thought was the fair value. Obviously we weren't in a position where we were willing to take a haircut on a case. We'd wait it out. And then when the courts started opening, I think one of the things that happened initially is the courts were bringing in the smaller cases, meaning the cases that had fewer witnesses that were only going to take a couple of days to try. And that's kind of been what the courts have done. Now they're opening up to those bigger cases, and we've had a bunch of trials that have taken place. I think courts trying cases and being open for trials is never going to do anything but increase the number of settlements, because I have what you call that backstop. It's either settle it or a jury is going to make that decision for you. So I think as time goes on, it will increase the number of settlements. But historically, what we've seen so far is we've had a bunch of trials. The bigger cases weren't necessarily affected by the courts reopening at the outset because they were really just taking those smaller, shorter trials.
Good, thanks, Joe. Let me tell you what the result of our participants in our poll was. 66% of our respondents said no, it made no difference in resolving cases that the courts were open, and 33% said yes. So Joe, could I have slide number 7, please? So these were some of the comments that we got from participants in our survey. You can see as more trials, judges were involved, judges are trying to push cases. Like you said, as more trials are held, there's more incentive to settle cases. Some judges facilitate settlements. The court deadlines forced both sides to focus on value, risks, and resolution. Although the courts are open, a backlog is apparent. We talked about that. And people said, I think we got used to cases not going to trial in 2020 and 21. Now that the courts are opening and cases are being set for trial, mediation is being pushed more and more, still virtual. So it seems like everybody's experience was borne out one way or another by the results of our poll, our survey. So the question that we wanted to ask after that is, let's go to slide 8. Did the backlog in the courts result in more settlements? We know that there was a tremendous backlog in the courts. Things didn't happen for probably a good portion of the year in 2020. And 2021, we've reopened, we have courts opening, we're having trials. So let me ask Jeff Schulman once again, let me start with you. Did the backlog result in more settlements? Jeff?
I think Joe hit it best, that you separated into two things in regards to the smaller cases and the higher cases. The real preeminent firms out there, they're not discounting their significant cases, but some of the lower hanging fruit and some of the more desperate plaintiffs' offices, you had an opportunity to get some cases settled during that pandemic while that was going on. And now, especially with the courts open, I think people are paying more attention to, even though there's a backlog, that there are trial dates and cases are being sent out for trial.
Good. And how about you, John? Did you find that the backlog resulted in more settlements? John Tambasia?
Absolutely. The counsel who were savvy presented their cases up front. They gave good demands and they were aggressive in pursuing it. And I will say this on behalf of the carriers, in order to keep the companies healthy, a lot of AVPs started getting involved in cherry picking cases, even big ones for settlement. So yes, the backlog helped.
Good. Nancy, from the claims perspective, did the backlog result in more settlements from what you saw?
Yeah, I mean, it was the only way you were going to move a case. So, and people were stuck at home and they were looking through their caseload and taking advantage of all the virtual means of communication. So I do think a lot of cases settled during the court closure.
Thank you. And Joe Block, same question. And your answer is about the same, that the backlog in the courts maybe made some cases settle, but not the ones that were really not the low hanging, not other than the low hanging fruit. Is that fair to say?
Yeah, I think the reason that, and you know, in the 7-figure cases that types of cases we handle, I think the reason we were able to keep those settlement levels at the same area, to both in terms of the value and the number of cases we were settling, we were able to do that. And I think for a couple of reasons. Number one, when you have that backlog, so when there's no trial dates, especially on cases that you have summary judgment on, now you've got interest running at 9%. And you know that cases are going to sit around now for years and years and years. So I think the carriers and defense counsel were really proactive in saying, well, hold on, these are cases we need to take a look at. They're only going to get worse for us. And with no trials looming, we need to continue to aggressively handling those cases and try and get them resolved. And they did. I also think it afforded all of us, by being home and it gave us the opportunity to slow down a little bit, I think, and look at our cases more in depth. We weren't wasting our time sitting in a courtroom for 4 hours for a conference, traveling to and from court. So it gave us more time during the day to really sit down, dig through those files, ascertain, you know, where's this case at? What are the facts? And is this right? That is something that we can get done. So I think those factors led to some cases getting done, you know, more quickly. And then obviously there was those cases that languished.
Joe, I apologize. I said Joe Block instead of Joe Donahue.
That's okay. Jeff and I share one brain. That's what we always say.
Right. But my question is, now that we're back as to where we are, did we lose that moment of reflection for us to take a look at those cases and give those cases some hard thought about maybe this is a case that we ought to get rid of now, that we're back in the groove, so to speak?
We absolutely should. I mean, as Jeff Miller always says, we're in the resolution business. So we should always be looking at those cases and saying which cases are ripe for resolution. From the plaintiff side, it's, you know, has the client gotten to maximum medical improvement? Are they still treating, or is there still an open question about a surgery? Have you done your due diligence in looking at all your pleadings with respect to all the different types of damages? Have you looked at your economic losses? Because you can't engage in meaningful settlement discussions until you have all of that information. But once you do, what are you waiting for? There's no reason to wait. Not saying that you're going to be giving anything away or taking a lesser number. You can always engage in those discussions, and if you can't reach a resolution, you can't. But there's no reason to wait and not see if a resolution can be had.
Just like Jeff Miller says, do it yourself. Let's get on the phone. Let's, you know, get an email going. Let's do something. Try and make those cases resolved, because
Absolutely.
you know, closed case, as they say, is the best case.
Closed case is a happy client.
That's right.
I've got a question from someone that's watching here. It says, from a defense perspective, how do you balance out not appearing too eager to settle when you have a bad case and increase that final number based on the signal you are sending? So I think that's a good question for Jeff Miller, who's a master negotiator and certainly handles a lot of very heavy cases. And so when we're dealing with a bad case and he doesn't want to signal, you know, that he believes it's bad, Jeff, how do you keep a poker face on that?
That's a good question. And we've dealt with that before with carriers saying, hey, I don't want to look too eager. The truth is, I always say, you could look eager to resolve, but don't look desperate. It's okay to let them know. We're acknowledging that this is a case we're looking to resolve. We're not desperate. We're going to pay fair value. We're not going to overpay, but this is a case we'd like to move, acknowledging the weaknesses on your side and the strengths on the other side, and then negotiating it from there. There's nothing wrong with going in and know, hey, this is a bad case. This is not a case that we want to put before a jury. It's the reality of it. You get credibility when you speak that way. there are times that you're forced to try cases, whether you're on this side or that side of the fence. There's somebody on the other side that's not playing ball with you, and you're forced to try it. But I never have a problem. And sometimes everybody says, oh, I don't want to ask for the mediation. I don't want to be the party. We're not the culpable party. There's 14 defendants and you're paying an obscene amount of defense costs. I have no problem picking up the phone and telling everybody, you know what? We're not the heavy, but we want to get this case resolved because my carrier wants to stop paying defense costs. So let's move the case. And as Joe mentioned earlier, it's the communication and it's the credibility and the relationships. And there's nothing wrong with, at the outset, saying, we're eager to settle a case.
Yeah, and I will just
Convey weakness,
piggyback on that. There's always, even the best case, there's always risk on both sides, right? Joe knows that he's going, to pick the best jury he possibly can, but that's no guarantee that he's going to get the number he wants. And so what Jeff was saying is, a plaintiff's lawyer has to give us an incentive to settle. If their demand is so outrageous or outlandish that it doesn't motivate or incentivize us to want to make an offer, even on a bad case, because they think they've got, look, I've got an 8-figure case and I'm not coming off of it, then, okay, well, then there's little incentive to mediate or settle and every incentive to try the case. So I turn it over to Joe. Obviously, even on the bad cases that you have, I mean, you don't take a lot of them. I know some, the best plaintiffs firms, they turn down the cases that might get them into trouble, but every once in a while, you probably have that case where you say, I shouldn't have taken it. And now you're faced with a mediation. How do you present that where you have to come with the poker face?
What I'd say is this, it's no secret. Jeff Miller is going to know if I have a case that's bad for me. I'm going to know if Jeff Miller has a case that's bad for him. So I don't need to posture. We both know when we have a good case or a bad case, and it's no secret. And I don't think there's any harm in being the one reaching out saying, hey, are you interested in sitting down on this thing? And the reason is this, whether you have a good case or a bad case, you're going to have a number that you're willing to resolve the case for. And that number isn't a set number, but it's in a range. Right? And if I go to a mediation with Jeff and I have a case that's great for me, and he doesn't want to settle it within the range that I'm willing to settle it in, I'm not going to settle it. And if Jeff has a case that's bad for me, and I'm looking for a number that he's not willing to settle it within that range, if I'm not willing to do that, then he's going to try it. And we both know that. So it's really no secret. So I don't see it as coming from a position of strength or weakness. You're going to have your number or your area of where you'd settle the case, and it's either going to settle or it's not. And typically, like I said, the gap, meaning that difference between where you see the case and where I see the case, is typically not a large gap. There are cases where that occurs, but that's not typically what happens. So I don't think there's any weakness in reaching out. And I think Jeff's right. Acknowledging in the problems that you have with your case when you do have problems is going to be helpful. I don't think you lose credibility. I think you gain credibility. And at the end of the day, if you can, it's willingness to try the case too. Like Judge de Blasi said, in terms of, knowing your adversary, I know Jeff Miller is going to be willing to try a case. I hope he knows that we're going to be willing to try a case. And I think at the end of the day, that gets everybody into a reasonable area to have fruitful discussions.
Joe brings
Well,
up.
if there's any doubt why Joe's so successful, I hope that eliminates any of the doubt, because that's really, we don't hear that enough from plaintiffs firms, that honest approach. We wish more firms were like Blackman Tool, where they're both highly skilled, want to try cases, but also very reasonable to deal with. Absolutely.
No
Anyway, Jeff
question.
Miller, I'm sorry to
Yeah,
interrupt.
no question. And Joe, you brought up a great point, and you just said it. And it's why you guys, as Jeff said, one of the reasons. You're not walking in there with an exact number. You have a range. And you're not drawing a line in the sand. And it's something we spoke about earlier, on the stubbornness and willing to negotiate and willing to resolve and willing to listen. You're walking in with a range. And I would tell you, you said something at the end when you were talking, and I don't remember the exact words, but it's this concept that I agree with you fully. If there was no card game, if there was no posturing, if there was no gamesmanship to these negotiations, and you ask people in most of these mediations to write down on a piece of paper what they truly believe a fair settlement value is on the case. Obviously, they wouldn't be equal all the time, but most of the time, we would all be within striking range. Those of us who really know how to value these cases would always be, and sometimes there's a premium. Frankly, there is a Block and O'Toole premium out there. I'm paying more for a case that you guys are prepping than Joe down, not you, Joe down the block who doesn't know what they're doing and isn't going to try the case and has to refer it out. You do get a premium for your skills. But in regards to a true valuation of a case, I've texted Joe Donahue, I've texted Jeff Block and said, hey, I'm going in on this case. It's not yours. Just here it is. It's a 240. The guy has a back fusion. He's 36. It's in this, I'm looking at it in this range. Where do you guys see it? And every now and then I'll get this is where, but Block and O'Toole may be looking for, but they're in the same range. And it's a true part of our business that if there was less of that game playing, and obviously we're all in the same business, and we say it's the resolution business, and there's relationships that go on, and there has to be, we're all looking to do the best we can for our clients. Everybody's looking to the best they can for their clients. But at the end of the day, without the animosity and without taking things personal and without the adversarial part of it, if you really sat down and discussed the case without posturing, most people are going to be in a strikeable range.
And usually that you meet that strike because within that gray range, you might take a little bit less than you were hoping for. You might pay a little bit more than you really wanted to, because you really don't have a settlement unless everybody leaves a little bit happy and a little bit unhappy. That's the way you reach resolutions, because the alternative is the risk. The risk that, leaving the hands of 6 people. And sometimes you're willing to take that risk because you're far enough apart. But most of the time you don't have to take that risk.
So it sounds like from talking with Joe and Jeff, we're in a new enlightened era. Because back in the day, if you remember this, I'm sure you do, you'd have an adjuster that would say, I'm not going to make an offer until I get a demand. And we've all had that where, the adjuster would not be moved until the plaintiff had taken the first step, kind of like that, that Chinese tea dance or something where everybody's got a scripted set of moves that has to happen. But it sounds like, things have progressed, that there's much more communication for the better, because now, if you don't have a demand, you can just call up and say, here, I got an offer for you. It may not be what you're looking for, but take a look at it and get back to me. Does that sound like what's happening?
Yeah, it's funny, in the last number of years, the amount of times I've gotten a call with an offer without having even asked for a demand or a demand being made has increased significantly. And, I always respond that, I really appreciate that. I really appreciate you making the call and making an offer. I haven't given you a demand. It shows that you're really looking to go into this in good faith to see if we can get it resolved. Let's get the discussions going.
Thanks. That's a great answer. And I wanted to move on to one of our next questions that we asked in our settlement survey. And it piggybacks on a lot of the stuff that we've been talking about. But the question was, were there more or less cases settled in 2021 than 2020? So let me just start at the top. Jeff Miller, more cases 2021 than 2020? What do you think?
It's really a hard question, and I know you have the statistical data. You would think that, the answer would be 2021 because, everything's open, people are back to work. But I really, in my head, believe that we had such a big push in 2020, more than ever. Like Joe said, we got the opportunities to really dig into our files because we weren't spending 4 hours in court on conferences. And there was a big push to move cases, I think, on both sides of the equation. It might have been 2020. I really don't know the answer.
You hold that thought. Let me ask John Tambasia. I'm going to go right down the line, get everybody's opinion, and then I'll tell you what the results were. John Tambasia.
For me, oddly enough, 2021 was pretty good for settling cases.
Let's see, Jeff Shulman,
I'm going to say 2020.
2020, okay. And Nancy, how about from your perspective?
I would have to say 2020, and I think it was due in large part because everything shut down in March, and when carriers saw that, the courts were not going to be back open by September. Well, now what are you going to do? You can't let the case just languish. So if you had what you needed on the file, you reached out and you made an offer. And I think a lot of the cases settled that way because on the plaintiff side, and Joe, you can chime in, with, doctor's offices closed, and experts not available because of the pandemic, you kind of just looked at what you had in front of you. We're all experts. We all kind of know where these cases are going to go, where they're going to end up, and people were going through them, and they made these offers based on what they had.
Yeah, I think although they were close, I think 2020 edged out 2021.
Okay, so let me tell you what our participants said. Our participants said the same amount of 55% said it was the same amount of settlements in 2021 as 2020. 33% say there were more settlements in 2021 than 2020. And 11% said there were less settlements in 2021 than 2020. So the majority of people felt that there were just as many settlements with the courts being opened as with the courts being closed. Now that may be just people's perceptions, on what their individual statistics were, but it seemed to be, from whatever happened in 2020, at least 55% of the people felt that it carried through and there were more cases settled. So that's a very interesting phenomenon. Not sure how to explain it, but that's what our participants said. Let's go to number 9, slide 9. These are some of the factors that people put down as affecting settlements. The carrier's desire to aggressively close cases, the length of time the case had been pending, the injury and the value of the case. A regulatory agency was looking at our financials, so there was a push to review all reserves for adequacy and closing all claims off the books. As more trials are held, there is more incentive to settle cases. So let me start again with Jeff Miller. Jeff, these sound like the factors that you saw affecting settlements. Anything that you would add or you would highlight in there?
There's no question, but I think that one of the things where I believe that carriers got concerned that their pendings were going to explode in regards to the backlog in the court system, and they were definitely more aggressive in pursuing resolution.
Did you find that, John Tambasia, from your carriers that you were handling in New Jersey, they were more aggressive because of the fact that the pending might increase so dramatically?
Absolutely, because one of the little items people forget about, and this is a tip, I guess, for settlement. In many states, Department of Insurance, Department of Banking Insurance does keep tabs on reserves and how many cases are moving. So in addition to reinsurance, this is another item to consider and be practical about on both sides.
Nancy, how about for you? Carriers' desire to aggressively close cases, does that tie into reserving and trying to close out some cases so monies could be freed up?
Absolutely. I think Jeff was spot on when he said that the adjusters and the carriers were afraid that their pendings were going to explode. We all knew that suits weren't being filed. And you were afraid that the day those courts opened and, there was not going to be any limitations on the statute, that all of a sudden you were going to get slammed. So they definitely aggressively closed their cases.
Good. Jeff Shulman, what was your perspective on this? Carriers wanting to close cases, freeing up reserves?
Yeah, no, I think they're all good points. I think another point that I see is particularly on labor law construction cases, if the carrier has a strong relationship with the insured, they're basically a repeat customer. They want to do right by that insured, and they're more active on those cases and more willing to settle. The cases where they've renewed, the insured might have renewed with another carrier, a runoff account, might not get the kind of attention, and it definitely can affect whether or not they're willing to put up authority or be more interested in pursuing the risk.
Good, thank you. Let's talk about the elephants in the room. Let's go to slide 10. And I know we'll have a lively discussion here because we've already broached the topic. As you can see, the Law Journal reported that New York was the third in nuclear verdicts. So obviously Florida first, California, and then New York. So the question was, did the fear of runaway verdicts, social inflation, nuclear verdicts, did that have an effect on settlements in 2020, 2021? Let me go back and ask Professor Beer, your perspective. From what you saw with the companies that you're involved with, did this drive settlements in the years that we're talking about? Professor?
Well, I'll tell you that certainly anecdotally, when I talk to my claims professional colleagues and certainly actuaries from other companies, there was definitely an influence. I've certainly heard claims or insurance companies represent that the concern, if you will, the fear of nuclear verdicts definitely changed their behavior. And I will tell you that in a couple of the quantitative analyses that I've seen, it did in fact have an effect. I don't know whether necessarily every single firm was involved, but I can tell you that there is clearly evidence that it affected behavior. And by the way, continues to affect behavior.
Now, do we know which way it affects behavior? More settlements, more expensive settlements?
Well, if you look at average severity, there's no doubt that the concept of social inflation is measured in a lot of different ways, or at least there's attempts. And average severity is one of the ways of doing that. So whether or not it actually went to trial, clearly the nuclear verdicts show up on ones that go to trial. But I will suggest that even ones that are settled, average severity has clearly increased. Now, again, you're going to hear issues. Don't forget, economic inflation is also affecting that. So medical costs, et cetera, are rising. But there are many people that I've spoken to who clearly feel that claims behavior has changed because they're very conscious of a significant increase in the danger of bringing something to trial.
Thank you. But let me ask a question though. Are we actually, I've mentioned this before, but I want to mention it again. We say nuclear verdicts, nuclear settlements. There's nothing more frightening than the prospect of something nuclear. Okay, you say that, and all of a sudden you get a visceral reaction, like Putin threatening something nuclear, whatever. Okay, are we actually making this into more than it is? Are we kind of like taking something and calling it something else? Because there's always been runaway verdicts going back to the 70s and 80s. If you got $1 million or $2 million in Brooklyn or the Bronx, that was considered to be a very, very significant verdict. Professor?
I'll tell you, I understand your sensitivity to the word nuclear, but from an actuarial perspective, when $150,000 claims start getting settled for $500,000, those are looked upon as nuclear settlements. Not nuclear in the sense of catastrophic globally, but clearly if you deal with the actuarial terminology of average severity. And of course, that's the big issue that you're basically looking at from an industry perspective. So the real measure of, quote, inflation, which would be the change in severity, in my opinion, is no doubt is there, even if whether or not it's 6-digit numbers or 8-digit numbers.
Okay, let me ask some of my attorneys on the panel. That would be Jeff Miller. What's your perspective? Are we just talking about the same thing, or are we simply saying that the severity and the intensity of the cases are getting more expensive to settle in certain venues, labor law, for example?
Yeah, it's a hard thing because I do believe that, I don't know that the severity has really increased per se. And I'm going to age myself, but I remember being a young attorney in this business and a 6-figure case being a substantial case. A $250,000 case was a big, big case. I'm not saying it still isn't, but the 750 was an extraordinarily huge number for me growing up, that somebody was getting $750,000. And now we're seeing 7-figure and 8-figure settlements just across the board. And, all of these fusion cases, fusion has been the injury of the year. A lot of, fusion cases. Between the pain and suffering and the economics, these cases have become 7-figure cases. And I think that not just in the last year of inflation, but in the last 5 years of life, that the numbers have just significantly crept up and kept on creeping up. And the numbers, I think it's just the numbers and the expectations, and maybe, no offense to anybody, the addition of the millennials to the jury pool. I'm not sure where it came from, but the numbers have become astronomical in my mind.
Nancy, let me get your perspective from claims. What's your take and your feeling on this social inflation and the constant rise that we have, and the case that used to be worth 250 now worth $2.5 million?
Well, actually, conversely, I remember when I started out in a soft tissue case, questionable liability, you would settle a quote unquote nuisance value case for $5,000, $7,500. I mean, those cases now, they're settling for $35,000 to $50,000. Not a big figure, but when you think, that's 100% more than it had settled in the past. So yeah, you've always had the runaway. But because of the severity and the frequency now, I think that that plays a huge part. I see, being in the broker side of the business now and talking to many adjusters with many different philosophies from many different carriers, they all have that one thing in common. We cannot try this case. We are afraid of a nuclear verdict. And whether it's nuclear, as Professor Beer had said, of $30,000 or $30 million, it's still a nuclear verdict for that case.
Okay, let me ask Jeff Shulman. Jeff, what's your perspective?
I agree with Jeff Miller that, we're about the same age and have seen, a pretty staggering but gradual increase on these cases. And all of a sudden, here we are in 2022, and when we're roundtabling cases, when we talk about a cervical fusion, we're just talking about a different level of and different range of a number than we used to. It's absolutely much more impactful in damages right now. The other thing that I will comment on, it was briefly mentioned by someone today, is, and I think it was Professor Beer, the Grieving Families Act. That's probably going to be signed into law after the November elections by the governor in New York. That will have a tremendous impact in wrongful death cases, and those will be nuclear verdicts that we're going to have to keep an eye on, and settlements.
And we're going to talk about that for our final topic.
Well,
let me go to Joe Donahue, and from the plaintiff's perspective, so we get a little balance here. What's your take on this?
It's very tough spot here. So what I did was, before we started, I looked at Webster's and I looked on, nuclear under litigation, and it was defined as fair and just. It's look, I've been practicing for 25 years, and I've definitely seen an increase in the numbers. But then you have your cases that go for far less than that, even though they have the injury. So it really comes down to a full assessment of both the facts with respect to liability and damages, the risk. And yeah, there's some cases that go very big, and some cases that don't. And sometimes I don't know the rhyme and reason behind it, to be honest with you. I could have a very similar fact pattern that, we're able to get a certain resolution, and, same fact pattern, where the carrier is not willing to pay that kind of number. And sometimes there's no rhyme and reason. It's just hard to explain.
Okay, let me go to Jack Jennings. Jack, you had mentioned when we had our webinar the last time on nuclear verdicts that there is a way to protect against nuclear verdicts. And you mentioned that excess insurance is one of the ways that a company or insured can protect themselves. So given the fact that we're now number 3 in the poll, and I don't know whether that's going to rise or not, but certainly it gets your attention because you see those statistics and you don't forget them. Do you find that there's more incidents of people protecting themselves, either companies or self-insureds or insureds, with excess insurance? What are you finding? Good news?
Yeah, well, the answer is no.
No.
A couple of the reasons that I'll cite for that, probably the most important reason, the largest contributor to companies staying kind of where they are, is the hard insurance market. If costs are up 20-30% for the same insurance we had last year, we're not going to buy more. And you have to get into the psychology of the corporate insurance buyer. Too often we adopt, either we're in the insurance business or we adopt the psychology of the insurance company. Who's an aggregator. So we're always working towards a mean of experience across all of our insureds. For the corporate insurance buyer, it's more binary. Either we had a loss, we had a tough case, or we didn't. In times when prices are up, and when insurance premiums are up, companies are loath to add more limits. And this is despite the fact that insurance brokers have analytical tools. They have benchmarking that says, here's what similar companies do in terms of umbrella and excess limits. And they have modeling capabilities, which, do simulations and, come out with some result. If you have 50 million of liability insurance, you have 95% chance of having enough coverage should you have a claim. With the binary thinking of claim, no claim on the part of the insurance buyer, they're not so moved by it. Insureds tend to consider buying higher limits when premiums are falling, and they say, oh, we'll take some of the savings and plow it into more insurance. And it's shocking to me that brokers and insurance companies are not in any way other than I'd call sporadic, prompting their clients or saying, look at these nuclear verdicts, or, you read the Wall Street Journal, about this situation. Why aren't you buying more insurance? It's not happening except, again, sporadically, certain teams, certain business units. You go on Google now and, Google hire and I use 10 different search queries and 0 results in terms of, hey, it's time to buy more insurance. Because insurance, we have to remember, to insurance companies, when the insurance mechanism works, this is not risk. Insurance companies should run towards risk of the individuals because they pool it, and when the pool works, they've collected, a lot of money, and sure, they're paying out 60, 70 cents of the premium dollar on losses, but the rest goes towards expenses and shareholders. That's my thought on that, Tom.
Great, thanks, Jack. That was a good insight. Do you think this is going to have a spillover effect and increase damages overall in cases?
I think it's going to be something very specific in regards to these wrongful death cases. One of the things that we always said to carriers was like, there's two good things in New York about personal injury litigation: the wrongful death statute and the snow in progress defense. I said, that's about it. And we always use that. And we're not even going to be able to say the wrongful death thing anymore because it just changes the whole landscape of what damages are recoverable. And those actions are going to be way more dangerous and going to be valued way higher.
Okay, I thank you for that. Jeff Shulman, you agree?
Well, I certainly agree that it's going to affect wrongful death cases dramatically. Do I think there'll be a spillover effect into other personal injury cases? I don't see that happening. I think that, each case is going to continue to be judged on the merits. I think that, when we reconvene in 5 years and look at the, inflationary pressures, and I think we'll see a slight increase in the same injuries, for the same fact pattern. I respect what Joe said about each case being different, of course, but, generally when we look at these injuries on different cases, if we compare apples to apples, I think we're going to see a natural increase. But I don't feel, although as dramatic as the effect is going to be of the Grieving Families Act on wrongful death cases, I just don't see it spilling over into other cases. I mean, maybe Joe has an argument to why it would, and I'm not putting words in his mouth. I don't know that he would agree or disagree.
No, I don't think it's going to have a spillover to other cases. I think this is going to be very specific to wrongful death cases. What the proposed law is going to do is just give certain causes of action for people who otherwise didn't have any recourse. And quite frankly, New York is one of 2 states in the country that don't have the recourse that the bill provides for those left behind. So I think I do think obviously anytime you create a new category of damages in a particular cause of action, it will obviously increase the monetary value of that claim, but I don't think it's going to have a spillover effect into, let's say, a labor law case with an injury that doesn't include death.
Do you think, Joe, that New York has certainly been way behind the curve in this? You mentioned we're one of 2 states. Is there any way that people can argue against this, given the fact that we're so far out of line?
Yeah, look, I think people could argue that the law shouldn't be passed, but I think that's an economic argument of not wanting to obviously, include additional types of damages. Personally, I think it's a just law that's been proposed in that it gives, whether it be a mother or a father or a sibling, some measure of justice if they lose a loved one. And we're dealing with typically minor children that, we've all handled those cases where the law just doesn't value the life of a minor child and doesn't leave any kind of measure of justice for family members left behind. So I think it's a good law. I think it's a move in the right direction, but it certainly will, obviously cause concern for an economic concern for people.
Yes.
Insurance companies.
Thanks, Joe. Professor Beer, what's the thinking from inside, the insurance companies about this law? Are they afraid of this law in the sense that it's just another way for damages to be increased?
Well, let me give you the quantitative answer, and that is, I think that the latest estimate was something like $2 billion of additional costs, which theoretically then has to get built into the pricing structure. So it needs to be addressed, and not to wave the flag that I waved earlier today, but this is a classic example of this audience has an opportunity to play a role in understanding, underwriting these type of risks. The colleagues that I'm dealing with today, obviously, they're on the front lines and they are very experienced. So when we talk about no spillover effect, it might not be spillover relative to specific cases, but theoretically it affects every form of liability, whether it be general liability, auto liability, products liability. All those lines of business could theoretically be influenced. So good underwriting is going to be necessary. So forgive me for avoiding the ethical issue. The fact of the matter is that if this law gets signed, it's something that the insurance industry is going to have to deal with and recognize and anticipate from a cost perspective, from a terms and conditions perspective, from an underwriting perspective, and obviously from a claim settlement perspective. So I guess I'm just looking at it almost as inevitable. That's certainly the theme that I'm getting from this group. And I see no reason to believe that it would be, given the environment we're in. I see no reason that it would be overturned. So from that perspective, the insurance industry is just going to grit its teeth and recognize that this is going to have implications and try to come up with an intelligent way of dealing with it.
Have you already started to come up with a response to this by way of pricing or anything else?
Well, theoretically, it doesn't exist, so therefore the price shouldn't affect that. If only that were the case with the price of gasoline, but let's leave that aside.
Right.
The important point is, though, that at this point, there'd be no reason to solicit regulators to allow you to increase prices simply because it isn't in effect. On the other hand, you better be prepared. You better be ready and having conversations. By the way, what it may lead to is companies being less anxious to write business in New York State. So let's make sure we understand that that's a possibility. But ironically, given the property risks that exist around the world, casualties become more interesting. So as Professor Jennings pointed out, the industry is very complex today with regard to hard markets and pricing. So I think they would just look at this as yet another example of an issue that has to be reflected in pricing.
Okay, that's a great answer. And that's something certainly that we'll have to take a look at. As we have mentioned, this has passed both houses of the legislature. It's awaiting Governor Hochul's signature. I don't think that anyone thinks that she won't sign it. I think probably she'll wait until after the election because we'd only give fodder to a campaign before the election. So we'll see what happens after it. But certainly it's something that we're going to have to keep our eyes on. And that's why we mentioned it here, because it does tie into our discussion about what the value of cases and what the value of settlements were. Let me just mention this. When we were talking about the settlements, were they the same, greater, or less than in 2020? 55% said they were greater in 2020, and 44% of our participants said they were the same. So that just leads some credence to the fact that, the value of settlements, the value of the claims, the value of the cases is probably going up. Maybe just a function of the times and the factor that everything is now seemingly more expensive. And we also have to factor in inflation. One of the things that we haven't talked about here is that we have been in a relatively low inflation era over the past 15 years or so. But now when you have inflation at 7-8%, things get much more expensive. And as jurors see that reflected in the costs that they're dealing with, they probably will be adding that into their calculations, maybe not explicitly, but implicitly when they start figuring out value of injuries. Do you think that's going to happen, Joe Donahue?
Yeah, I think, jurors look at things exactly like we do. How far does your money go? And, how can that possibly not affect, if plaintiffs proven their case in terms of liability and damages, the value of those damages, they perceive it, how do they not include that into their analysis? And I think you're right. I think it's just done, implicitly. I don't think it's something that maybe they consciously think of, but it's just, hey, it's going to cost this much to go to a doctor, or this much to just survive. And that just automatically will transfer over to verdicts, I believe.
Okay, thanks. anything that anybody can do on the defense side. Jeff Miller, Jeff Schulman, John Tambasia, Nancy, dealing with the issue of inflation, just plain inflation and damages, not just social inflation, just inflation of everything, all the costs that we've got.
I think part of it is keeping the whole, trying to stress the reasonableness, and keep on hammering the reasonableness of, but the reality is, at one point in time, I thought my $1 an hour babysitting was a great earnings. And my daughters are like, we're not doing that for $18 an hour. And that's who's going to be on the juries. And that's where the numbers have gone.
And I agree with that. When Joe puts up Blackboard's numbers, has an economist saying, an electrician who is injured is going to, project it out over the next 20 years, make X. It's hard to dispute that, especially if they have tables to back it up, union tables to back it up. One area that is effective, I think, for defendants and I find fuel for cross-examination is on life care plans. I think there's always information in there that you can, if you get down into the nitty-gritty, you can find stuff that could really defend those claims pretty well. I've never seen a life care plan that was ironclad the way an economist might project out a wage, and that probably will ring true with inflationary pressures too.
Good, excellent. Well, we're running up on our finishing point, and I wondered if there were any questions from our participants, whether anybody out there wanted to ask anything before we finish our webinar today.
Yeah, we have no open questions now, but we've had great questions along the way.
As we wrap up our first Pillinger Miller Tarallo Claims Settlement Institute, I do want to thank all of our participants for taking the time to join us today. I also want to thank, in particular, our panelists. Obviously, you guys are great, and you give us your time, your insight, and your experience, and we thank you for that. We hope that we've added value, that we've advanced what we would like to call, a value-added proposition, and create a value to advance the art and science of settlements. That's our goal with the Claims Settlement Institute. We want to gather like-minded individuals from our different stakeholders and try and come up with an interesting program so we can address topics that are relevant. And if anyone has an idea that they'd like to have us cover in a subsequent CSI, please feel free to contact us. As I mentioned before, I'd like to thank the people at St. John's for their help. I'd like to thank Joe Levine for his particular help putting our program together. And of course, all our participants, Jeff Miller, Jeff Schulman, John Tambasia, Vincent Kalinoglu, Joe Donahue, Jack Jennings, Al Beer. I don't think I'm forgetting anybody. And I want to thank you on behalf of Pillinger Miller Tarallo for being a part of our inaugural Claims Settlement Institute. So thank you very much and have a nice evening, everyone.